So let's start off with a little bit of a review. This chapter starts off reviewing previous sections that we've had. But we're going to specifically cover the federal court system. So we said that we have multiple layers of courts. What are our layers? Federal is one of them. What is the other? Below the federal court system, we also have a jurisdiction of civil. So we have the federal courts are divided into criminal and civil and appellates and case, right? Yes. Okay, just like this morning, we've used the same recording process. So below the federal system, we have the states, right? So this specific chapter is going to cover federal, and then we'll cover the states in another chapter. What document gives authority to the courts? Yes, absolutely. Article 3 of the U.S. Constitution. Yeah, exactly. So that afforded the Congress to be able to create courts and things like that. But that doesn't mean that we didn't have courts before the Constitution, right? I mean, we as a country, we migrated and declared independence from another country, England. And just because we have Article 3 of our U.S. Constitution doesn't mean we didn't have courts once we came over here. So courts in and of themselves were not created by Article 3 of the Constitution. It just gave some rules and authority based towards the courts. So we also had a little bit of a division when we came into creating this country. Representation and how the courts are going to be built, how the legislature, was going to be built, how representation was going to take place, which states are going to be more powerful than other states. We had some states that had a whole lot of people, Massachusetts and things like that had a whole lot of folks in them. And then we had states like Rhode Island that didn't necessarily have nearly as many people, and how do we make them equal? There were two schools of thought so if you were a bigger state with a lot more people, then what board do you think you would want to use as a factor or measurement of how much representation you have? Probably population, right? Exactly. So the more people you have, then the more powerful you are. But if you're Rhode Island, how do you counteract that? How do you combat that and make things more fair? You could give the same number of representatives to every state. If Massachusetts, for instance, or a highly populous state, wants to use the number of people that live in that state to determine how much representation they have, then in order to combat that, then you could say, well, no, let's not do that. Let's just make everybody equal. And then Massachusetts, in theory, is going to say, well, that's not fair. How is Rhode Island going to have the same number of representatives as me? I've got so many more people. I deserve more representation. What does that sound like? What are we describing there? Does it sound a lot like the Senate and the House of Representatives? Yeah, so we ended up coming up with a compromise. One thing. So something to remember. James Madison was I want to make sure I have the right person. James Madison was a big proponent of something called the Virginia Plan. And the Virginia Plan said, hey, that's exactly what he's talking about with Massachusetts. The Virginia Plan was, let's use how many people we have in each state to determine how much representation there is. But we had to, every point has a counterpoint. So the opponents of that had the New Jersey Plan. You've got the Virginia Plan that says, hey, use the population, and the New Jersey Plan says, let's use equal representation for all states. So the compromise to that was, our bicameral legislature, which says we now have a Senate and a House of Representatives. So how many senators does each state get? That's the equal one. So every state differs by the number of representatives they get. But there's the same number of senators in every single state. How many is that? Yeah, exactly, 2. So when we came to that compromise, that great compromise, it gave us the 3 branches of government, and then within the legislative branch, what we call a bicameral legislature, which means we have two different houses, the House of Representatives and the Senate. Article 3, going back to Article 3, not only did it give us authority to create the federal court system, but it gave us a tiered system within that court system. So by not necessarily, so we've said that you can have crimes of omission, and you have crimes where you have to actually say that something's illegal. The Constitution is the same way. In Article 3, by not clearly saying that it couldn't happen, it gave permission for states to create their own courts. So states can, we are the United States. We believe in the fact that the states' rights and states have this autonomy that the federal government doesn't always have the authority to step into. And so the Constitution grants the powers to the state to create their own court system, which oftentimes mirrors the federal court system. And so the vast majority of laws that we see broken and tried, convictions are going to come from a state system. Because the Constitution, Article 3, gave that permission to the states. So going back to the federal system, there's an act that I want you to write down, because this is what we're going to discuss over the next few minutes, and I'm almost positive we're going to see it again. The Judiciary Act of 1789. Judiciary Act of 1789. So we don't have just a Supreme Court, right? The federal system, we've said the federal courts are several layers, including the Supreme Court and those lower layers, excuse me. So that Judiciary Act of 1789 created those additional tiers within the court system. It spelled out the jurisdiction for every single one of those courts. We have different districts and circuits that we're going to go into. It spelled all that out. It spelled out how these lower court judges were going to be selected and some of the rules that they had to follow. Rules like, so currently, if you're going to represent a district, not a judge, we'll go back to the legislature. If I am a senator for the state of North Carolina, I have to live in North Carolina to represent North Carolina properly. If I'm going to represent the people of North Carolina, I have to live here. So when this Judiciary Act of 1789 was put in place, it said the same thing about judges. Judges had to live where they're going to be appointed. And it divided the country into 13 judicial circuits. And we talked about the appeals districts that we have. We're in the 4th, California, the West Coast is in the 9th. So, but outside of the appeals, the actual lower court circuits, it divided the country into 13 of those. And then put a district judge in charge of every one of those districts. Those 13 districts, when this was initially, remember this is back in the 1700s, so we didn't have a law of land. We started out with only 13 colonies, so we had 13 districts. Those 13 districts were then divided into grouped into 3 circuit districts. And the last thing that that act created was the size of the Supreme Court. The Supreme Court at that time, based on that act, was one Supreme Court or one head justice and 5 associate justices. So 1 Chief Justice and 5 Associate Justices. Later, throughout the years, different acts and different rules were created that eventually expanded the court, even to today, when there is discussion of expanding the court even more. What are some of the advantages of making a rule to expand the court, the Supreme Court? We talked a little bit last week about the president gets to appoint judges, the Supreme Court justices, well, all federal judges, but the nominations are made by the president. So if the president leans in one specific political viewpoint, and that viewpoint is outweighed on the Supreme Court. So if they're currently, hypothetically, if we do have 9, so we have 9 justices, if 5 of them are conservative and 4 of them are liberal, what would happen if we had a liberal-leaning, a left-leaning Congress and a left-leaning president, and they made the decision to increase the size of the Supreme Court from 9 to 21? One, it would go through a little more easily, yes. So we have 9, so that means 11. In that hypothetical situation, 11 justices are up for grabs. How many of those 11 justices do you think that the left-leaning president, the liberal president, and the liberal Congress are going to approve? They're probably all going to be liberal. So what does that do to the way the court was leaning? So we had 5 court justices that were conservative and 4 that were liberal. And then they decided to make the rule, change the rules and say, now we're going to make 21 justices because that's what we want. If they make that rule and they appoint 11 new justices and 11 of them have a left-leaning, a liberal ideology, which way is the court lean now? Liberal or conservative? Liberal. Yeah, absolutely. Yeah, liberal. So that is a way to the term is called court packing. So that is a way for somebody who's currently in power to ensure that their ideologies are seen through not only the executive branch, but the judicial branch as well. So I told you there's a very limited number of judges at the beginning, and based on the way the country is laid out and the transportation and abilities, they were traveling judges. They had to go to these different courthouses within the districts and hear these cases. One of the things to provide relief for that was in 1869, Congress approved 9 new judges, which was a godsend for them at the time. So now they could essentially have more time off instead of having to just constantly travel from courthouse to courthouse to courthouse. Just the mere adding of 9 judges, not in the Supreme Court, but just in the circuits, was something wonderful for them. The next Judiciary Act I want to talk about is the Judiciary Act of 1891. Judiciary Act of 1891. So you'll notice that thus far we've only talked about the districts, the district judges, and Supreme Court. But now, what do we have between those two? Currently in the United States, if your case is heard at in the district court, the lower level court, and you don't like what your outcome is, where can you go? Yeah, what's the next level above the lower courts? The appellate court, yes. Yes to both of you. So the Judiciary Act of 1891 established those. Established 13 U.S. Circuit Courts of Appeals. 13 of them. It also gave the rules as to what cases they were going to hear. It specified that district courts of appeal were going to hear the appeals from the district courts, from the lower courts. Because now that we have appellate courts, the Supreme Court doesn't have to hear every case. So we have one more piece of, one more act that I want you to remember, the Everts Act. EPA RTS, Everts Act. And that's what put on paper that we're going to ease the caseload of the Supreme Court. Because before that, before the appeals courts, if you didn't like how your case went at one of the lower courts, you had to appeal to the Supreme Court. And imagine how many cases there are that are going on all the time. And in every single case, somebody's not going to like what happened. Doesn't mean that everybody has grounds for appeal, though. Remember, appeal isn't necessarily, I use it colloquially, I don't like what happened, but there has to be a grounds for an appeal. There has to be some sort of constitutional question or procedural misstep, things like that. Merely because I don't like the fact that I was found guilty, if there were no mistakes made and someone's found guilty, there's no ground for appeal. So let's talk about those lower courts. U.S. district courts. These are the lowest level of the federal system. This is what we call the entry point for the federal court system. Cases are going to get heard here first. You can't just start out at the Supreme Court. You can't start out at the Court of Appeals if your case has never been heard. There are 94 district courts spread over the country. And if there's 94 entry point courts, do you think we have more or less appellate courts? Not every case is going to be appealed. So we're going to start out with a wide, it's going to look like a pyramid or a triangle. So we've got 94 of these lower courts and significantly less of these appellate courts until we only have just the one Supreme Court. So I would imagine that number, 94 district courts, is a significant number for you to remember. Why are we seeing less appeals than cases? I told you one of the reasons, because you have to have constitutional ground, right? Is there a lot of constitutional ground? It can happen, but is there a lot of constitutional ground for a case wherein somebody pleads guilty? Is there a lot of room for appeal? No, because in general, if somebody pleads guilty, they accept the responsibility for what they've done, and they're going to be sentenced accordingly. And every once in a while, you'll see a case wherein somebody pleads guilty and then realizes, hey, my rights were violated and I want to appeal that. But in general, because there are so many cases, we talk about 95% of the cases they go to court in this country, not just in the federal system, but 95 cases that are presented to the court system, only 5 of them go to jury trial. That means we're taking pleas or dismissing 95% of those cases. So if we're doing that, that only leaves, in general, those 5% that went to jury trial that are going to be within the realm of possibility for appeals. So that's why we have far more lower courts than we have courts of appeal. So we started out with just about every colony and every state having their own court, but now, because of population changes and things like that, you'll see there's states that have more than one judicial district. Texas, California, New York, they have as many as 4 districts within their one state. But in general, like a rule of thumb is that you'll see just about 1 district per state. So that leaves not just the states, but there are some territories that have courts as well, and I want to make sure you guys are aware of that in case that comes up again. DC, District of Columbia, has some court district, as well as Guam and the Northern Mariana Islands. So really obscure locations, but since they are territories, they are eligible to have their own courts. So just like back in the 1800s when they added 9 judges to the field of judges to help those traveling judges work their workload and their caseload, back in 1990 we had another expansion. So not that long ago in the course of our history. But in 1990 we had an expansion of 74 new positions, new judge positions. So that expansion, combined with the one we talked about, combined with all the other little ones that, throughout the years, brought our authorized judgeships for the federal lower court system to 678. Doesn't mean that we have 678 judges because there's vacancies, they're still waiting to get filled. So remember, on our view, once the president nominates a federal judge, who approves that federal judge? The word we use is confirm. Who confirms a federal judge? Congress, exactly. So currently we have several judgeships open, but Congress is doing their best to work through it. They have a lot of jobs, right? They've got to confirm judges. If there's a Supreme Court nominee, they've got to confirm that. They've got to confirm all these cabinet members. Plus, they got to do their day-to-day legislating. They've got the creations of budgets and laws and things like that need to be approved. So they're wearing a lot of different hats. They work as fast as they can reasonably work in order to get these judges confirmed. But just because we have all those vacancies, just remember it's going to take some time to confirm them. So we have 678 authorized judgeships, which doesn't necessarily mean we have 678 judges sitting on the bench at any given time. So what do these district court judges do? If they're the lower court judges, and that's the entry point for the criminal justice system on the federal level, give me some ideas of what a federal judge, what kind of cases they hear. The easy one is criminal cases, right? Federal criminal cases, the entry point, if somebody's arrested for a federal crime, they have to go before a federal judge to have their case heard. Some of the other things that they do. Have you guys ever heard of a consent decree? Sometimes when organizations, you'll hear it a lot in the law enforcement world. So if a law enforcement organization has been making maybe some bad decisions, some officers have been getting in trouble, and they have a history and a pattern of bad practices, then the federal government can sue this police department and then be in control of that police department. It's happened to New Orleans, the Los Angeles Police Department. Can't think of off the top of my head all the other agencies. But if there's just a history of scandal or corruption or things like that where they think that you need some oversight, they will put into place what is called a consent decree. And there's a judge that is placed in charge of watching and overseeing that organization. They're still going to have a chief of police. They're still going to run their day-to-day activities, but all these day-to-day activities are going to be reviewed by a judge, and that's going to be a district judge. It's going to be a district judge. That's one of the jobs a district judges have. They also hear these petitions from convicts, so not necessarily a full-blown appeal, but if you're going to write a petition and start the appeal process, what you have to write is a writ of habeas corpus. And that's going to be a writ or a letter or documentation of why you believe there are some constitutional violations in your case. For instance, you could believe that the search was illegal. It was unconstitutional. and that's what made that search illegal. So if the officers arrested somebody and searched their car and found whatever it is that sent them to jail, and that person believes that that search of their vehicle was unconstitutional, then that writ of habeas corpus would have to be sent to a federal judge, and the district judges, the lower level district judges, are the ones who review those habeas corpus writs. One of the things that they don't hear, though, so we hear criminal cases, they hear, they review these higher level case decisions to make sure that they're applying them to their courts. That's another one of their jobs. They review these writs of habeas corpus. One of the things that lower court judges don't do at the federal level are federal bankruptcy hearings. There are special judges that are not necessarily, remember how long are federal judges appointed for? Whole life, forever, ever. So when you can talk about these other types of lower court judges that aren't necessarily full-blown federal judges, remember they're going to have different lengths of service. Only the district court judges and above are going to have that lifetime appointment. So a bankruptcy judge, they have a 14-year appointment, and that's what they hear just that bankruptcy cases. Then we have U.S. magistrate judges. They can be appointed by or selected by these lower level district judges. And they have 4 functions, and we're going to go over them here. They conduct most of the initial proceedings in criminal cases. So if there's some administrative functions that need to be done before the criminal case is heard by a federal judge, then these magistrates are going to hear them. They're going to take care of kind of that admin aspect of things. If there is a federal misdemeanor, a magistrate can hear that. A federal magistrate can hear that. If there's a civil case, a non-criminal civil case that's to be heard, as long as both parties of that civil case consent, then a magistrate can hear that case as well. If one party doesn't consent, then it has to go before a full district judge. And then the 4th function is kind of a catch-all. Just any other functions, any other jobs that some of the district judges can get, those lower administrative functions that aren't necessarily affiliated with beginning a big court case. So the appellate courts. Remember, the Supreme Court is an appellate court. We just don't call it that because we have a series of courts that hear these appellate cases. Because the Supreme Court, we told you in the beginning, they were hearing every appeals case. They just can't afford to do it. They can't budget their time enough to hear every case. How many cases do you think the Supreme Court hears every year? Throw out some numbers. We'll see. 10. 10. All right. Any other numbers? 10 cases a year? 50. 50? I'll take one more number. 30. 10, 50, and 30. About 100. Which is still, I mean, you guys are right on the right around the right, because that's not that many cases for one court to hear an entire year. I told you some of the preliminary court that I used to when I was an officer. Some of the preliminary cases that were heard, they would hear sometimes 20 or 25 prelims in a day. So to hear 100 cases in an entire year, obviously they need to be very, very selective, and they have to have a good system of appellate courts that's going to screen those cases for them. And that's something to remember. One of the primary jobs of the appellate court system is to be like a screening system for the Supreme Court. To weed out those cases that can easily be decided that don't necessarily need to go before the Supreme Court. So kind of like a Supreme Court bouncer. They're gonna screen those people that get in. So these cases, where do these cases coming from in the appellate case? The appellate courts. Where are they getting their caseload? Are they hearing cases the Supreme Court heard already? No. So they're always going to have that upward movement. So these lower court cases are going to create or generate the appeals cases. So I know I've said it a couple times, but one of the things that creates an appeals case or a caseload for the appellate court is if one party or the other is not satisfied with the results of that case. And by satisfied, it has to be just a little bit more to the satisfaction than just I don't like it. There has to be what we call grounds. So those grounds can be, like I said, constitutional questions for the witnesses. Officers would be witnesses, or the arresting agency would be witnesses to that case. Who else can make mistakes in a case? So if that's what we hear about the most, we hear about appeals because of an illegal search. But there's other people involved in a case or a trial. Who else is involved in a trial that could make a mistake? Lawyer, yeah. So maybe there's some sort of misconduct on the lawyer's part. Exactly. Can judges make mistakes? Yeah. There's a lot of decisions in a court case wherein they have to decide whether or not evidence is going to be let in, or testimony is going to be allowed, or stipulations can be heard, things like that. So all those decisions are up for debate if that case doesn't go the way that one party or the other wants it to go. So if that judge makes a decision and says, no, we're not going to allow that testimony is prejudicial, or that testimony is neither here nor there, it's irrelevant, we don't need to hear that. Then later, one of the parties who's dissatisfied with that decision and then dissatisfied with the results of the case can use that as their rationale to take that up to the appellate courts. So I told you they're a screening system. The appellate courts are a screening system for the Supreme Court. And I alluded to the fact that the Supreme Court gets to choose which cases they hear. They're only going to hear 100. They weren't just handed 100 cases. The Supreme Court, and we're going to go into it, I believe in one of the next chapters, exactly the system they have in place to choose which cases they're going to hear. However, the appellate court does not have that power. The federal appellate court has to hear the cases that are presented to them. They have no discretion, no choice. If a case comes up, they have to hear it. The other thing that they are tasked with, and specifically you need to remember, is a job function. So our lower courts, we're hearing criminal cases, right? Guilt, innocent. And the whole point of a case is to be it's a fact-finding mission. We want to know what happened. So we've got one party that says ABC happened, and then you've got the adversarial system, which means that the opposing party says XYZ happened. And then the court has a function of finding out which is truth, ABC or XYZ or ABX or some combination therein. Fact finders are what lower courts are. Appellate courts are not fact finders. Their job is not to figure out innocence and guilt. I told you some of the reasons why you can appeal these constitutional questions, these illegal or improper decisions, things like that. What is being considered at the appellate court level is that specific question. So when you appeal a case from lower court to the appellate, you're not appealing, they found me guilty and I didn't like it. Can you have my case heard again? The appellate court is not going to hear your case again. The appellate court is going to hear why. Well, the judge said that they didn't allow in these two witnesses, and these two witnesses would have really helped my case, and it was improper for that judge to not let those two witnesses testify. And then they're going to argue why the judge, one side's going to argue, well, here's why the judge didn't allow them, and they're going to say, here's why the judge should have allowed them, and then they're going to make that decision and then decide, okay, once that decision is made, do we send it back down to the lower courts to have a new trial? But we're not going to have a trial here at the appellate court. We're only going to ask those specific questions of appeal. So how do we appeal these cases? How are these cases heard? We know how trials take place. Tell me, let's talk about the adversarial system. I know since that was a paper coming up, I want to hear, I want to review that. How does the adversarial system work? I said a little bit. We've got two sides. What are our two sides in the lower court? Right, exactly. The defendant or the defense is one side, and then that means who's the adversary? The prosecutor or the state or the people or whatever. You know, they're all the same thing. State, people. In the case of the federal court system, we wouldn't call it the state; we'd call it the people. And those cases are going to be here. Can we just write in general? Can the prosecutor just write down a bunch of notes and say, this is my case, and give it to the judge and jury? In general, is that something we do? We see? No. Same thing with the defense. We can't. The defense isn't going to write down a bunch of notes or documents or motions. They can in some instances. If you plan on making a motion to either suppress evidence or make some legal moves within a case, the parties can write and document those arguments and give them to the judge to read previous to their arguments. It gives the judge a heads up. But in general, for an entire case, we don't write those down. Cases aren't heard on paper. That's different at the appellate level. At the appellate level, they have the option to lay out their entire appeals case on paper and write it down. And those papers can then be reviewed by the appellate courts. Why do you think it's allowed there and not at the criminal level in general? What do we have at the criminal, or sorry, at the lower level? The lower courts. What do we have at these lower initial entry point courts that we don't have at the appeals case? If all we're answering is just one minor question, do you think we have witnesses in general at an appeals case? No, I always get exceptions. So a lower court case is going to have evidence, witnesses, an entire adversarial system where you're going to put on a case that's going to prove beyond a reasonable doubt. Takes a lot of moving parts. Well, if you take away all those moving parts and you just are answering a very specific legal question at the appellate level, you don't need those witnesses, do you? You don't need necessarily all that evidence that said that that person was guilty or innocent. You don't need to present all those facts. All those items are not up for debate. The only thing up for debate is that one or two those one or two specific legal questions. And so without the need for witnesses or presentation of evidence or pieces of evidence, I'm drawing a blank on the word, exhibits. Without the need for exhibits or evidence or witnesses, why would we need to present our cases? We don't necessarily need to have a passionate appeal to a judge or a panel of judges in order to get our appeals case heard. All we really need is just get the ideas across. Those ideas can be heard via writing